Good morning, everyone. We're pleased to have you with us. We originally had 4 cases set on the docket, but we reluctantly granted motions to continue. And so the 2 cases before us today will have our undivided attention. Please recall that each side has a total of 15 minutes to argue, and that applies whether one or multiple attorneys are arguing the case, and the appellants have the right to reserve up to 5 minutes for rebuttal. So when you come to the podium after you've introduced yourself, let us know how much time you wish to reserve, and the clock will be set accordingly. And please recall that your arguments are being live streamed and recorded, and the recordings will be posted on the Administrative Office of the Court website. Any announcements or introductions? Hearing none, call the first case, please.
Karl Robert Kokko et al. Versus Thomas L. Moore Jr. et al.
Good morning, Mr. Caparella.
Morning, Your Honor. Donald Caparella, National Bar, along with Tyler Yarbrough and Jacob Vanson, who's not here today.
Okay.
We represent the appellants in this case.
We didn't give him a continuance.
He hopefully will be here. Today was his son's first day of kindergarten, which he didn't want to miss.
Oh, my goodness.
He has good work-life balance, I guess you would say.
I cannot remember that far back.
There he is. So I'd like to reserve...
How was the traffic at the kindergarten this morning?
The traffic at the kindergarten was not terrible. The traffic coming into downtown Nashville.
Okay. Well, I'm sure your firm can deal with the traffic and conditions too. So, all right.
I would like to reserve 3 minutes for rebuttal.
3 minutes, yes, sir.
Your Honor, there are primarily two issues before the court. First, whether the trial court abused its discretion in granting a default judgment against the driver defendants, and secondly, whether the trial court erred in granting summary judgment in favor of the Kokkos and against the Moores for breach of contract. I'd like to begin with the summary judgment ruling first. The trial court failed to follow the most basic rules of summary judgment. He didn't view the evidence in the light most favorable to the non-moving party, and he didn't resolve any genuine issues of material fact in the non-moving party's favor. The 2 issues on summary judgment were whether there was a mutual assent to the contract terms resulting in an enforceable contract and whether a breach occurred. Those are normally questions of fact. Trial court listed 39 factual findings in its memorandum. 34 of them were taken verbatim from the opposing sides, the movement's statement of undisputed facts, and the Moore disputed several of those. They're identified in the brief. I can talk about individual ones if you'd like.
So the ones that you're relying upon today, you specifically denied them and cited to the record.
Correct.
To support your denial.
Correct. But even more striking is that the Moores introduced or filed 20 additional material facts that they said created a genuine issue for trial. What we have, the frame I'd like to put the entire argument in, which I think makes it make more sense, is you have an escalation clause that's buried into, well, it's not buried, it's front and center in the purchase and sales agreement that the Kokkos introduced. And it says, in the event of multiple offers, the buyer agrees to offer $1,000 over the highest offer up to $800,000. Seller to provide proof of competing offers. And I submit that language of that escalation clause puts the timing and sequence of the offers as material facts. And if the timing and sequence of the offers are disputed material facts, then summary judgment should not have been granted. And I can focus on one particular fact that's in the statement of additional facts that was hotly disputed. And this relates to whether Angela Walker, who was the agent for the Kokkos, was aware of the $730,000 higher Mokar offer that came in at 5 p.m. on January 22nd of 2021. And the question is, was the counteroffer that came in after that known to the Moores, and the Kokkos. And so the Kokkos know of this higher 730 offer, and therefore, does that mean that the escalation clause would automatically kick in and require them to make an offer higher than that? And this is the testimony, it's very short, of Angela Walker in her deposition. She's asked, and remember, she's the agent for the Kokkos, so whatever she knows, the Kokkos know under law. So did you understand when you learned of the offer, the Mokar offer, that it was $10,000 higher than the Kokkos? You knew that, right? And she says yes. And you knew that before the Kokkos accepted the counteroffer made by the Moores, right? And she says yes. That puts right into the center of the whole summary judgment discussion whether or not the Kokkos and the Moores could even enter into a contract for something less than that when the higher Mokar offer undisputedly had come into Mr. Irby's office.
What did the trial court find about that?
I'm sorry, what?
What did the trial court find about those facts?
The trial court made no finding about that. The trial court made no acknowledgement that there's even 20 additional material facts that were introduced and responded to by the Kokkos. The trial court simply ignored that completely.
So, by the same token, what Mr. Irby knew, the Moores would know, correct?
Under the that's true.
And didn't Mr. Irby indicate that he was aware of the Mokar offer while he was working on the counter offer? So the Moores would be aware of Mokar at that point.
Well, it's very disputed what Mr. Irby knew and what he did with it. There's multiple different material issues of fact about what Mr. Irby knew and when he knew it. Now, we do know that there's testimony that Mr. Irby never communicated the amount of the Mokar offer to the Moores. The Moores said they never knew about the Mokar offer and what the amount was. So they did know that. There's other disputed testimony.
So, basically, you're saying when it comes to the Moores, what Mr. Irby knew can't be imputed to them. Because he clearly was aware of Mokar and the 730 when he was working on the counteroffer. I mean, I think the statements seem to indicate that he didn't worry about that because he was working on the counteroffer.
Well, the counteroffer was sent after the Mokar offer came in. Now, when Mr. Irby actually saw the offer, even though it clearly was in his office at 5 p.m., is disputed even by Irby. He's unclear about what he knew and when he knew it. He also testified that he thought it wasn't a good offer. It was sloppy. It was incomplete. It wasn't a good offer. So it's hard to impute disputed facts to the Moores. You can't really get summary judgment that's true. Now, however, on the other side, the Kokkos, according to Ms. Walker, did know that there was a higher offer out there, although that is also disputed because in subsequent testimony she contradicted some of that.
Yeah, there's a lot of information in your brief about how the escalator clause is to work in this instance, and indicating that there is a dispute about the proper interpretation of that. So I am looking at counteroffer number 1 that your client sent to the Kokkos. And point number 1 says the purchase price per the buyer's escalation provision is to be $721,000. If I were to receive that counteroffer, it seems to me, my view would be, okay, we're done with the back and forth on price. They've said, we're going to take your escalation clause on your original offer, we're countering at $721, and that's going to be the number. Why isn't that the proper interpretation of the agreement?
Well, the trial court never interpreted the agreement. So this court would have to, for the first time, interpret the agreement and try to make all sense of this. But this matter comes to this court on summary judgment. So the trial court should be the first one to try and interpret this, and the trial court never mentions the escalation clause.
Well, can't we do that, though? I mean, that's a question of law, the proper interpretation, unless there's an ambiguity here. And so I would think that we could do that on the first instance.
Well, the reason why that doesn't work in this case is that the parties have to have a meeting of the minds. They have to assent to the actual terms. And the Moores say that it's automatic that the 730 offer has to be higher than. And the Walker and the agents also testified that they thought it was automatic. But the Kokos dispute that. So they don't even agree on how this operates.
Yeah,
So
so,
that,
well,
go
so
ahead.
let me stop you there, because here's where I'm having trouble following, is at the point the counteroffer gets sent, and we say, per your escalation clause, the number's gonna be 721, again, I don't understand why the number would ever vary after that counteroffer. Once the Kokos sign that, I would think you're done at that point.
Well, in that same counteroffer, Your Honor, it says, all other terms and conditions of the original attached purchase and sale agreement are acceptable to the undersigned. So I think that the escalation clause is still in play, or at least that's a material issue of fact about whether it is in
And
play.
so, and here's the other part I was having trouble following, I guess, in the analysis, is you talk about the escalator and how long the escalator works in a case like this, under this agreement. Under the Moore's interpretation here, that escalator works when? Until the moment of closing on the Kokko deal? Is that the way it would work?
It works as long as there is another offer that comes in before the counteroffer is finished, and that
Okay, so
happens.
that's the question. When would the counteroffer be finished under the Moore scenario here? When you set the absolute price here?
Well, what's interesting, another material disputed fact in this case is Mr. Irby said that there is no deadline. The 6 o'clock deadline wasn't applicable. So theoretically, I mean, the Moores believe that once the MOCAR offer came in, as long as there was not a signed written contract at that point, then it was an obligation of the Kokos to beat the 730 offer. And the Kokos knew about it. So how that works is the kind of thing that a trial court resolves after a trial, respectfully, not on summary judgment.
So is any proof in this record that shows that the Moores actually presented the MOCAR offer per the escalation clause to the Kokos to say, I mean, I know you say the undisputed facts show that Ms. Walker was aware of MOCAR's offer.
Correct.
But did the Moores, and does the record show that the Moores took the formulaic step of actually saying, here's MOCAR's offer?
Well, Irby, I mean, I think it's pretty clear that Irby told Ms. Walker about it, because the Moores and Ms. Walker.
So
were
let's take it for
communicating.
granted that Ms. Walker
Right.
was aware, but it seems like to me under the escalation clause, there's a formality to it where to prove that there is this higher offer, you have to actually present the purchase offer to the Kokos. Did that ever happen?
The escalation clause just simply says to provide proof of offer. It doesn't say written proof. It doesn't say the actual offer. It just says proof. Well, as Your Honor knows, from most of you, I think, were trial judges, at least 2 of you were, proof can be testimony. You know something, and clearly she knew something. So it doesn't say it has to be written proof, and she's clearly aware, or at least there's a material issue of fact that she's aware, and that raises the question about how this escalation clause operates, which the trial court never resolved, and the trial court never addressed any of these additional facts and how it would work out. So you'd essentially have to be doing the trial court's work, which he did not do, and basically step into his shoes and do summary judgment based on what the trial court did. So we submit that would not be the proper role of the Court of Appeals. The trial court needs to follow the rules for summary judgment. So it looks like I've got 12 seconds left. So
Sorry.
no, I started with that, and so it's on me. I will just rely on my brief on the abuse of discretion on the default judgment. We believe that's simply outside the normal scope of what anybody would grant default judgment, because there was no severe prejudice and there was no extensive delay in that case.
And you were not counsel for the defendants in the trial court?
No, I was not. And also the lawyer for the Moores, when the Moores didn't show up for the deposition, was different than Mr. Jackson, who became the lawyer for both sides later. And when the court imputed essentially the misconduct of the drivers to the Moores, they didn't even share the same counsel, not that that really even matters. So we submit that the trial court abused its discretion in granting default judgment as well.
All right, thank you. You'll have time for rebuttal. We'll hear from the appellee. Good morning.
Good morning, Your Honors. I'm John Hill of the Lincoln County Bar, along with my law partner Ray Fraley. We represent Mr. and Ms. Kokko in this matter.
Glad to have you here.
Thank you, Your Honor. Since the focus of the appellant's argument was on the granting of the summary judgment, I guess I'll jump to that to
Yeah,
start.
tell us why the automatic raise of $1,000 doesn't foreclose the case.
And I think Judge McBriar was kind of closing in on this in his questioning. There's a reason why there was a 721 counteroffer in this case, and that is because another offer came in from a gentleman named Ogletree for $720,000. When the $720,000 offer came in from Mr. Ogletree, a copy of the offer redacting Mr. Ogletree's name was supplied along with this counteroffer of 721, and that everyone understood that we had the escalation clause applied in that situation because they had provided proof of the offer from Mr. Ogletree, and they had made a counteroffer. Well, they never followed the same procedure with this MOCAR offer. There was never a redacted copy of the MOCAR offer presented. There was never a counteroffer presented for 731.
So was that in the statement of undisputed material facts? That it was never, I mean, I know it's always difficult to put a negative in a statement of undisputed facts, but it seems like to me that would need to be an essential part of the summary judgment process. Hey, we never received the actual purchase for MOCAR before we signed off on this counteroffer.
Yeah, I believe it was, and with respect to the allegation that the court whole cloth adopted the statements of the Kokkos and their statement of facts, I think we made 39 assertions of facts in our statement of facts filing with the summary judgment motion. I believe 34 of those were admitted by the defendant in this case, and at least fully or partially, and I think there were 5 that were denied, but if you go back and look at those, they have incomplete citations to the record. Some of the, and this is set out more fully in our brief, some of the citations to the record, when you pull it up, it makes no sense. There's a citation to the record of a conflating Ms. Walker's name and Mr. Irby's name as Angela Walker Irby, so it wasn't even clear which deposition you were talking about in that situation. So I don't think it's any mystery why the court adopted many of the findings of the Kokkos, because most of those were admitted.
So you're saying we can focus on the 5 facts that you rely upon that they disputed, but what about the 20 facts that the defendants relied upon?
And Your Honor, many of those facts have shared the same deficiencies as the response to our facts. They either had, they were lacking in proper citations to the record, or they were citing to parts of the record that in no way supported the facts themselves.
Speaking of procedure, I mean, I am concerned here about the default that was granted on the discovery violation. Looking at your brief, it strikes me that you're also sort of hopping on this idea that, well, you can also look at the Moore's conduct here and impute that to the Waynes. I mean, I know in the final conclusion you say, well, there was 2 clear orders that the Waynes violated here. When we typically see these defaults and people complain about entry default under a discovery abuse, it is normally a much longer string of conduct to justify that. 2 orders, I mean, to me, that is very worrisome.
Well, we did do a motion to compel in this case, and I think what you see in my review, there aren't that many cases where a court is overruled on this, but the few that I can think of, there was never a motion to compel. So we have a violation of the scheduling order, we have a violation of the agreed order that they agreed to as far as the timing. And I would point out that there was never a phone call to say, I'm not going to be able to meet this deadline that I agreed to. There was never a filing with the court seeking some kind of relief from that order. They just simply let that date come and go. And that's, without any
But,
kind of.
even under the best case scenario here, let's say the Waynes got these responses and Mokar got these responses in a timely fashion. You are still, even in that scenario, really up against the deadline for completion of written discovery, or you're not. I mean, it was interrogatories propounded on March 1. I think the scheduling order provided a April 16th cutoff for written discovery. Is that correct?
I can't dispute those facts.
Yeah,
Your Honor.
so, well, don't trust my memory on any of that. But, I mean, you were still very close. What's your best argument of the prejudice your clients suffered due to the Wayne's delay? What's the best argument you have for that?
And Your Honor, I believe you have to consider that we were all operating under a scheduling order at that point. There was a 90-day window for completion of depositions once the 90-day window for written discovery was finished. So by the time we actually got partially responded written answers, we were virtually halfway through the deposition 90-day period, and we had to reschedule depositions, and it really threatened to just topple the whole schedule of the case.
Well, but I thought the Wayne's depositions weren't scheduled till June of that year. So by the time the default hearing was held, I mean, the depositions were still the next month. So I don't understand where the prejudice is here from the Wayne's conduct, and that's what I'm struggling
Well,
with.
and we wound up taking depositions beyond the deadline. The scheduling order had to be adjusted to allow for depositions.
Which
because-
suggests that there really wasn't much prejudice here, right?
Well, Your Honor, I would respectfully disagree. I think the trial court, on the ground saw prejudice here in how they handled that.
So what do you say the prejudice is? Was there a trial date set?
There was.
Okay. Was the trial date moved? Well, you didn't have a trial date because summary judgment was granted, but.
Well, no, the trial date was ultimately moved because the summary judgment didn't go to the damages. So we would have had a trial for the damages. Now, partially that trial date was moved because of a Rule 9 filing that was pending that ultimately was not granted. So that I think the trial court felt like, with that up in the air, that was part of the reason for moving the trial date.
Did the trial court articulate any prejudice?
I believe he did in the record, and I'm not sure how well I can articulate that this morning. I would point out that the sanction that was imposed here did not prevent the drivers in Mokar from participating in the trial to determine the damages in this case. So I think the sanction imposed is more akin to 3702B, where a disobedient party is not allowed to support or oppose a designated claim or defense, as opposed to a case where, like, a plaintiff's whole case was dismissed because they didn't participate in discovery. The defendants were certainly allowed to and did participate in the trial of this case.
And when you say the trial on damages, the trial court didn't grant damages because it granted specific performance. So you're referring to the attorney's fees and costs? Or?
Well, there were additional money damages being sought in the case, and there was ultimately a trial to determine money damages, both against the Moores based on the contract, and I guess before I forget to point out, we've also filed created an issue in this case seeking our attorney fees on appeal based on the contract, which allows for the recovery of attorney fees when you're having to file a suit to enforce an agreement. But we also filed suit against the drivers in Mocar for interfering with the contract, and those damages were entirely set at the trial.
Yeah. But a default was entered against the drivers in Mocar, correct?
Just as to their
Liability.
liability, yes.
Okay, all right. So they were able to participate, but, just on the damages phase, and that was the award of attorney's fees, okay.
And in my brief, I've gone into some case law that talks about, deference to the courts.
Right, I mean, yeah, I agree. I want to give the trial judge a fair amount of deference, but I do want, when you're going to do what's close to the ultimate penalty in a civil case, a default, I mean, it says contumacious conduct. And so I always want to look and see that established in the court's order. And I'm really, two violation by the driver, I think I was calling them walkers earlier, but I meant the drivers, just doesn't seem like contumacious conduct.
And, well, we have violation of two orders. I mean, I think that's tantamount to the contempt of court, which is the definition of, one of the definitions of contumacious conduct that's in the American Express case, is to say it's the sort of thing that could be prosecuted as contempt of court. So we have violation of two orders here. And another point I'd like to quickly make is, though the trial court didn't know this at the time he made this ruling, in subsequent depositions we found out that Mrs. Driver signed two sets of her personal set and the Mocar set of interrogatory responses, and she didn't even know what she was signing by her own testimony. She didn't know anything about interrogatories. She hadn't participated in preparing any interrogatory answers. Her testimony was basically that when my husband tells me to sign something, I sign it. There is a line of cases that talks about perjured discovery responses having the harshest penalties.
Well, but what I hear what you're saying is, it almost sounds like it's an attorney problem and not a client problem here.
Well, the only explanation they ever provided was to say that we were having trouble getting some text messages off a phone, but there were interrogatories propounded to three parties and requests for production propounded to three parties. They only produced documents in response to one party, the other two did not, in the interrogatory. So that only would apply to one set of requests for production of documents. They never explained why they could not get the interrogatories answered in a timely manner. And looks like my time is up, Your Honor. Thank you.
Thank you. Thank you.
I'm sorry, I was splitting my time with Mr. Hickey this morning.
Oh, did you tell us to split the 15 minutes?
Yes, Your Honor.
Huh?
He's gonna do 3 minutes.
Oh, good, very good. I didn't hear that. I'm so sorry. Okay, but be glad to hear from you for 3 minutes or so.
Yeah, yes, sir. My name's Thomas Hickey. I'm from the Hamilton County Bar. I represent Karl of Nashville. I don't have much to add to the underlying basis of the lawsuit. My client had an intervening petition in this lawsuit because it had an exclusive listing agreement with the Moores for a commission on the sale of the property that's at issue in this case. It was a 6% commission. And what I would just add to what has been discussed is that subsequent to the Kokko counteroffer coming in, the Moore counteroffer to the Kokkos that was accepted, there was discovered an error in the contract. So subsequent to the counteroffer being accepted, there was a second document that was sent to correct the error that was then re-signed by the Moores, which was well after the disclosure of the full amount of the Mocar offer. So I think part of the questions—
You mean the 730?
Yes, yes. So that information was available, I believe the record reflects, either the day after or shortly after to the Moores, after the Mocar.
So this counter offer number one really is not the final agreement. So where do I find, what's the record citation to what you would?
So the re-signed counter is Exhibit 6, Trial Volume 22. So there was a date that was incorrect. It was dated January 2nd, 2021 instead of January 22nd.
Okay, and I
2021.
remember that point now. What about the financing contingency? Did that appear in that Exhibit 6?
That I don't know from memory.
Okay.
I didn't recall there was a financing contingency. I thought they had the funds available, the Kokos, to buy.
Well,
the
I thought there
property.
was one and then they waived it. No?
That might be correct.
Okay.
I don't think they were relying on borrowed funds to buy the property.
No.
So I think for our purposes, we had just a very standard exclusive listing agreement. There does not appear to be any dispute in the record from Mr. Moore that he knew the terms and conditions of it. In fact, the Moores actually ended up sending out correspondence, and there's record testimony that they just didn't want to sell the property. They didn't want to sell it because they didn't need to, and they were considering listing it or using it as rental property, and that included not selling to Mokar. So they just pulled the property off the market. Interestingly, they later on sold the property to Mokar for $681,500, which represents a discount because they didn't pay the realtor fee, or didn't have to. That amount equaled $725,000.
And they retain the right to use the property on certain occasions.
I think there was some testimony to that respect. Nothing, I don't think there was ever anything formalized in writing, but that was a contention.
I want to understand what happens with your client's position depending on the disposition of this appeal. Obviously, if we affirm, your clients are fine on it. If we reverse, then your clients are back in court. Except, I guess we could say that the one was voluntarily dismissed, one was granted summary judgment. I guess we could affirm in part on that. What would happen? What's the impact on your clients were we to do something in the middle? For example, affirm the grant of summary judgment between Kokko's and Moore's, but reverse the default entered against the drivers and Mokar.
Well, that's an interesting question, one I was discussing with counsel earlier. I'm not sure that there was any pending claim against my client by the Mokars. I'm not sure how that would affect me as it relates, or excuse me, Karl-like. I'm not sure how it would affect my client as it relates to their recovery against the Moores.
For the commission.
For the commission.
Yeah, okay.
So if the contract, if the summary judgment is affirmed and the case sent back, I don't think that disturbs my judgment.
Okay, gotcha.
Thank you.
I think my time's gone. Thank you, Your Honor.
Do you agree that Exhibit 6 represents the final offer?
No, I do not. There's a failure to have a meeting of the minds and assent to the terms of this contract because there was no agreement as to how the escalation clause worked. The trial court didn't resolve any of those things. I noted my closing counsel says that our responses to the statement of undisputed facts were deficient, and the statement of additional facts were also deficient. The trial court made no findings to support any of those, and we strongly dispute that, and it's set forth in our brief about how we strongly dispute it. So again, you're going to be, respectfully, essentially doing the trial court's summary judgment work properly as opposed to what he did. So,
Well, but you would say, though, under a Rule 56 review standard, we take a de novo look at everything and make sure that the requirements of summary judgment were satisfied. So as part of that process, we typically do go through and look at the statement of undisputed facts and the responses and make sure that they were fairly disputed with citations to the record.
well, we believe, we have no problem with that, and we believe we'll come out just fine with that, Your Honor. Now, the finding of prejudice that Judge Stafford that you asked about, The only finding of prejudice in the default judgment was that the driver defendant's conduct hampered the Kokko's ability to prepare for the upcoming depositions of Greg Driver and Daphne Driver. Now, on May 6th, there was an agreed order the parties agreed to, said that on May 6, 2022, they got an extension to May 6th to provide their interrogatory responses. As of May 6th, the driver depositions were set on June 9th, 34 days later. So by getting the responses to discovery on the 22nd, the only prejudice that happened was they lost 18 days of that 34 days preparation time for a June 9th deposition, which opposing counsel just told you didn't even happen on June 9th, it happened later. That is the only prejudice, Your Honor, that the trial court found was hampered the ability to prepare for a deposition, and they just lost 18 days. So that was
a specific remedy requested from the trial court, for instance, a default judgment or sanctions such as attorney's fees requested, or was that just, we've got a problem and we're going to, trial court, you decide what to do?
No, the motion was for a default, strike the answer, strike all pleadings, and essentially declare that the driver's reliable. And that's exactly what the trial court granted in the absence of any opposing counsel being there on that day. So it was all about, no other sanctions were asked for. The trial court didn't award any lesser sanctions against the drivers. So,
well, let me pose you this question. I realize you're out of time. I know the Supreme Court has granted an application for permission to appeal on a similar case within the past 30 days regarding basically entry of a default judgment. What does, or what is it what is your understanding of the law at this point regarding the escalation of remedies to be provided in this matter as opposed to what is normally called the nuclear option here?
well, there's the specialty care case lays out the criteria for when default judgments should be affirmed for not properly responding to discovery, and the criteria for when default judgment should not be affirmed, again, for failure to respond to discovery. And the two key factors that are missing from this case are a delay of more than a year, clear contumacious, well, three factors, no obvious contumacious conduct, and thirdly, the lack of any real prejudice other than hampering for a deposition. So that, the state of the law is in the specialty care case. I'm not familiar with the case that Your Honor just said they granted review on, so I don't know how it lays on this, but the court might provide some guidance as to how it should be ramped up. But I've seen other opinions say that you should consider lesser sanctions and not go straight to the default judgment option without doing other things, and that's not what happened here.
Thank you.
Right. Thank you, all three of you, for your arguments. We'll take this matter under advisement.